Welcome to another edition of Dad's Divorce Live. I'm Matt Allen, editor of DadsDivorce.com. Today I'm joined in studio by Will Howes, an attorney with Cordell & Cordell, and we're going to be talking about contempt. Will wrote a series of articles on contempt, so we'll sort of break those down. We'll talk about what exactly is contempt, what conditions must be met to prove contempt, and consequences of contempt. So first off, Will, what exactly is contempt?
Well, basically, contempt is not doing what you're supposed to do. It has to be in the order. So if it's something that your former spouse or the other parent of your child is doing that you just don't like, that might not rise to the level of contempt. But if your spouse is disobeying a court order, either by doing something they're not supposed to do or not doing something they are supposed to do, then they could be in contempt of that order.
Does it have to be, is ignorance a defense? Does it have to be a knowing violation of the court order?
Yes, they have to know that what they're doing is against the court order. And one of the easiest ways to do that is just for it to be in the order. If it's in the order, it's presumed that you knew that you were agreeing to that condition.
So how do you prove that someone, how do you prove contempt?
Well, it's going to vary from case to case, especially because it has to go back to that order. So, for instance, if somebody is withholding time, well, the dates that you're supposed to have time are in that order. One of the ways to prepare for that would be, to keep a calendar of when you're supposed to have time, and then compare that to the order. And like I said, it's going to vary from case to case, so each different type of contempt will have its own different way to prove it.
So can people, we hear every day about like child support roundups where people go to jail. Can people actually, will you go to jail if you're in contempt of court?
Well, it's possible. Typically in civil court, which is what family court is, contempt is not used to put someone in jail. They'd rather have you or your spouse or your former spouse pay the support. So what they'll do is they'll give you an opportunity to cure your contempt, either by making payments, or they'll give you an opportunity to show why you weren't able to make those payments. That's one of the affirmative defenses to contempt.
Are there other consequences?
Yes, you can. The judge can do anything from modify the court decree, your child custody arrangement or your visitation arrangement. He can order you to pay the money. He can order you to pay additional fees, including attorney's fees. And pretty much, the judge's ability to punish or to coerce compliance with the order varies based on what the judge wants to do.
Now, you mentioned modification, and I just want to clarify this point since we get a lot of questions about it. Can orders be modified solely on the fact of contempt of court? Is that all that's needed?
Well, the reason behind the contempt would also potentially be a reason for modification. I would speak with your attorney to determine whether or not they think it's in your best interest to file a motion to modify alongside your contempt. Often that's the way that we go about modifying an order, is pairing it with a motion to modify.
That was Will Howes, an attorney with Cordell & Cordell. I'm Matt Allen, editor of DadsDivorce.com, and that'll do it for this edition of Dad's Divorce Live.